Good afternoon, everyone, and thank you for joining us. I'm Maria Scotland, and today I'm joined by Stephanie Coker. We're both in the family team at 5 St Andrews Hill. We're going to talk to you today about nuptial agreements. We are all aware of the fact that the law changed after the landmark case of Radmacher and Granatino in the Supreme Court in 2010. What we want to do today is to take time to consider the guidance in Radmacher, and then our intention is to walk you through how the law changed and in what way the courts have been applying the guidance of Radmacher post-2010. For this webinar, we've read and digested 18 reported cases over the period 2010 to 2022 at mostly High Court or Court of Appeal level, with the aim of drawing together the judgments to see how Radmacher has been applied and what we can learn. Our aim in the time that we have together is to consider, firstly, what is a nuptial agreement? Then we'll consider the guidance of Radmacher. We'll then go on to consider the 2014, 2016 and 2018 recommendations of the Law Commission and the Family Justice Council guidance and the effect it had, if any, upon the Radmacher guidance. Then we'll move on to consider our summaries of the 18 cases we've selected in the period 2010 to 2022 to look for practical guidance. So we'll pull together the case summaries and consider how this should impact your practice, where a nuptial agreement is being considered or is one of the factors in the case. We'll consider also key points for drafting a prenuptial agreement, and then we'll go on to consider the court process, the applications where there is a nuptial agreement. Finally, hopefully we've got time, we'll take any questions if there are any. If you have any questions as we go along, please do pop them in the Q&A box at the end. They will then come through to us. We've got Tessa Narodzinski sat in the background, who's also assisting us today, and she'll be also looking out for questions and passing them on to us for us to consider at the end. Thank you.
Thank you, Maria. So what is a nuptial agreement? A nuptial agreement is an agreement between the parties before or during a marriage or civil partnership that seeks to regulate their financial affairs in the event of a relationship breakdown. Such agreements help to provide certainty and security if a marriage or partnership breaks down. And it's also a good way of entering a marriage with full knowledge of the financial picture. It gives couples more control to make their own arrangements for the future, rather than leaving everything up to chance and potentially costly court proceedings in the event of a divorce. The parties may agree on what jurisdiction a divorce or dissolution suit will proceed or take place. Nuptials are not formally binding in England and Wales. They are regarded by the courts as persuasive and even decisive following the Radmacher case, which Maria will now go on to.
So we next consider Radmacher. Now, it is something which we're all aware of, but it's worth reflecting for a couple of seconds back on what Radmacher decided. So in Radmacher, it was a case where a prenuptial agreement had been drawn up in Germany between a French husband and a German wife of substantial means. The parties were married in London and living in England at the time of their separation. In both Germany and France, their prenuptial agreement would have been enforceable. The prenuptial agreement provided no financial provision for either spouse in the event of a divorce. The wife appealed the first instance decision to award the husband approximately 5.8 million, despite the existence of the prenuptial agreement, which on appeal was successful in the Court of Appeal and subsequently upheld by the Supreme Court. The Court of Appeal held that insufficient weight had been given to the existence of the prenuptial agreement, and Lord Justice Thorpe, in his leading judgment, said he believed that it had become increasingly unrealistic for the courts to disregard prenuptial agreements or postnuptial agreements, and that insofar as the rule the nuptial agreement's void survives, it does not sufficiently recognise, in his words, the rights of autonomous adults to govern their future financial relationship by agreement in an age where marriage is not generally regarded as a sacrament and divorce is a statistical commonplace. The Supreme Court set out guidelines as to what weight should be given to a nuptial agreement as follows. The parties must enter a nuptial agreement voluntarily without undue pressure. The parties must have been informed of its implications. The parties must enter a nuptial agreement. Sorry, I've already said that. There must be material disclosure of all assets in the case. So information about what assets each has. Each must receive independent legal advice. And finally, the court should consider fairness, whether the nuptial agreement meets the needs of the parties and any children of the family at the end of the relationship. Ultimately, the Supreme Court held that respect should be given to individual autonomy and to the reasonable desire to make provision for existing property. In the right case, a nuptial agreement can be decisive or have compelling weight.
So after the Radmacher case, the Law Commission issues its report on marital property needs and agreement in February 2014. The Law Commission recommended that nuptials could only be a qualifying agreement if certain criteria were met. The first was that it must be freely entered into, it must be contained in a deed, it must be signed by both parties, it must be made at least 28 days before the wedding or civil partnership, there must be full disclosure of the other party's financial situation, and both parties must have received legal advice. The Family Justice Council published guidance in June 2016, and in April 2018, focusing on needs, cases, and providing summary of the law. I'd encourage most of you to read that document, because it's actually very useful.
We now move on to consider the 18 cases which we've collated, which included the nuptial agreement and have been reported in the years post-Radmacher, mostly at High Court or Court of Appeal level. What I've done for the purpose of this webinar is I compiled a spreadsheet of the cases, and for the purposes of comparing and deriving some assistance from our research, I pulled out the same factors from each and inputted them into a spreadsheet. I've broken that spreadsheet down into separate slides in the hope that you can read this. But what I should tell you is that after this webinar, anybody who's attended will be sent, should they want it, copy of these slides together with our details. So if you've got any questions, please do get in touch. My first slide simply lists each case. And what you'll see is 1 to 18. Number 18 at the bottom is the case of Radmacher. So this is listed in chronological order and date order, with the most recent being at the top and Radmacher at the bottom. And what you'll see is I've got a case in 2010, that was Radmacher in the Supreme Court. And thereafter, there are 3 cases in 2011, all at High Court level. Then I've got 1 case in 2012, 1 case in 2013. There are 2 in 2014, 1 in 15, 1 in 16. There's no reported case that I could find in 2017. And what I ought to tell you is that I used LexisNexis PSL as my research tool. And I've got 2 in 2018 and going upwards. And you've got the most recent, we've got 4. So we've got a rash of cases in 2021, which Stephanie will go over in more detail. But this first slide is simply to identify the dates of the cases, the judge in the case, the citation, and then the case name. So that's just for identification purpose. But my next slide, what I did was I went to each of the judgments and drew out of it the parties' ages in the case, that's husband and wife, their nationalities, the length of the marriage, and whether there were any children of the marriage. And by children, I meant under 18, or else any children, I do apologise, that's me, and whether there were any children with any disability. So any children that would have been considered as part of the Section 25 factors, and if so, how many? And I then went on to identify the judgment, whether the nuptial agreement was upheld or not. And I've adopted a traffic light system. Green means that the nuptial agreement was upheld, and red means it was not. And what is immediately identifiable is of our 18 cases, so at the bottom we've got Radmacher, where the prenuptial agreement was upheld. In the years post then, of my remaining 17, I've got 4 where the prenuptial agreement was upheld. So in other words, was persuasive and the court made awards in the terms of the prenuptial agreement. But I've got for the most part, you've got 13 where the prenuptial agreement was not upheld and awards were made for outside of the remit of the agreement reached between the parties, either pre-marriage or post-marriage, which we consider surprising and worth a further look. So it's readily apparent that 13 out of 17 cases, which is 76.5%, so let's call it 75% of cases, the courts are finding there were reasons primarily of fairness to depart from the nuptial agreement, and only in 4 out of 17 cases, or 25%, the court upheld the prenuptial agreement. So we go on to look at perhaps reasons why. We don't delve into every single case in detail, but as I said, I've drawn out facts to look for trends and see whether or not we've got short marriages, and it might be those cases are being upheld or not. So you'll see as I said, I've listed columns, parties, ages and nationalities. What is immediately apparent is most people are getting divorced in their 40s and 50s. We've got a couple of people or a couple of spouses who are slightly younger or slightly older, but the most part, you've got 40s and 50s. And then when you look at length of marriage, there's no trend with length of marriage, I'd suggest. You've got a really short marriage of 2 years in the case of L&M, where the prenuptial agreement was upheld, even though there was 1 child. And so what becomes or a question is, are these prenuptial agreements being upheld where there's a short marriage and not when there's longer? But what you can see from this column is no. The answer is no. You've got another case at the bottom. If we look at G, B and L, no, sorry, the one above it, Z and Z, got 14-year marriage, 3 children, prenuptial agreement upheld. The one above, 6-year marriage, 2 children, prenuptial agreement upheld. But then you've got other cases where you've got similar lengths of marriage and the prenuptial agreements were not upheld. And you've got similarly shorter length marriages, prenuptial agreements not upheld. So there doesn't seem to be a trend related to length of marriage, nor indeed number of children. As I said, in the case where you've got a 14-year marriage and 3 children, prenuptial agreement is upheld. But looking up to Chahin and Lim, you've got no children, prenuptial agreement not upheld. What is apparent on my last column, where again I've got this traffic light system, you've got prenuptial agreement upheld in the case where I've indicated it was not upheld. Then I'm going to give a short summary of reasons why. And for the most part, the court departed from the terms of the agreement due to fairness, not meeting one or the other party's needs in the event of the breakdown of the marriage. Only in 2 cases, the prenuptial agreement was not upheld and was ignored because of the proximity to the date of the nuptials. So in Ipeki and McConnell, I've said that right, apologies if I haven't, the prenuptial agreement was signed by both parties 15 days before the nuptials. And I believe that was the case where the wife's father was extremely ill with cancer, and the court accepted her case that she was not in a good state of mind to have been signing such an agreement. And you've got another one immediately above, AD and BD, where the nuptial agreement was signed the day before the nuptials. But other than that, the trend appears to be, by reading these cases and digesting them, fairness. So we then go on to look at a couple of cases in depth. Stephanie's going to do a deep dive on 3 of our most recent cases.
Thank you, Maria. So I'm going to discuss 3 recent cases from the spreadsheet. I'll set out what the parties' positions were for the court regarding the nuptial agreements. And I'll focus on how the courts dealt with the nuptial and how that relates to needs, going back to Maria's point about fairness. It should hopefully show how the fact of a nuptial agreement impacts on the award made. And again, Maria's point about the awards in most parts being below 50% of the assets, so no avoiding sharing in essence. So the first case is WC and HC, and this was a case of this year heard by Ms. Justice Peel. Very briefly, the background. The parties entered into a prenup and a postnup. They both provided, I think the postnup provided the wife with about 50% of the assets, and that included child maintenance as well. The total assets were 12.47 million. The wife did not sign the postnup, but her lawyers confirmed that terms were agreed. Both agreements recorded their parties' clear intentions to exclude the husband's inheritance, which might be in excess of 100 million euros. Almost all of the total assets came from gifts and inheritance from husband's family or owned by him before the marriage. The husband proposed the wife should have 7.15 million of the assets, and that was broadly consistent with the postnup. The wife argued that she should receive £10 million, and that went up to £10.6 million in her open offer. So in the end, the court found that it would be unfair to hold the wife strictly to terms of the postnup agreement, as it was insufficiently meeting her needs. Nonetheless, the court determined that she had freely entered into both agreements. That's very important to note. And they carried some weight, even if not determined of her claims. In the end, the wife's income and capital needs required an award of 6% of the total assets. So that was, I think if you look at the spreadsheets on the screen, that's 7.45% of million of the assets. And in terms of a capital division, it was 32%. So I think the last column on the spreadsheet, that's the second row, last column, wife's needs assessed at £4 million, and that came to a 32% division of the capital assets. And she got a Duxbury award of £3.31 million. So I think there, looking at the capital division, it's clearly less than 50% of the assets. I think something to note from that case that there were cost implications for the wife because how she ran her case. So while she was able to go behind the nuptial agreement, I think things to bear in mind when it comes to costs in these cases. So she had a cost order against her of £150,000, and that was set off against the award that she got in the case. So some reasons for the cost award against her were because her the outcome was well below her claims. So if you recall, her most recent offer was £10.6 million, and she ended up receiving 7.15. So that was clearly less, about 3 million less than that. The wife did not succeed in arguing undue pressure or that she needed a second home in Switzerland. And that was like a main difference between both parties' needs cases. The husband's approach throughout was that the postnup, though unsigned, was decisive. And it was only in closing submissions that he tempered this to highly influential. So whilst husband wanted to rely upon the postnup, I think something to bear in mind is that clients should be, I would say, sensible in how they're putting that across the court in light of the position when it becomes clear what parties' needs may be. And again, the court noted that the wife, I think neither party was flexible in their open negotiations. The husband did not move from his first position. He maintained that the postnup should remain, and wife increased her claims as the case progressed. So again, a practical tip for clients is to pick your points sensibly when litigating and to negotiate reasonably once the financial landscape becomes clear. I think that would apply regardless whether there's an nuptial in place or not. A second case, just to quickly look at, is Turan and Lim. So that was from 2022, and that was heard by Sir Jonathan Cohen this year. So in that case, the wife was arguing that the nuptial agreement was vitiated by the husband's coercive and controlling behaviour towards her. But in any event, she argued that the nuptial did not meet her needs, and her sharing claim was equal to or greater than her needs claim. So she had two arguments. One, that the nuptial was vitiated by the controlling coercive behaviour, or alternatively, that she had a sharing claim and the nuptial didn't meet her needs. The allegations of controlling coercive behaviour were denied by the husband. He argued that in any event, it didn't matter if the allegations were true, because there was no causal connection between the allegations and the wife's state of mind when she signed and entered the agreement. The husband's case was that the wife freely entered into a nuptial agreement and the terms of it met her needs. And if the court took a different view, he argued that there was no sharing claim and any needs should be modest. So having heard both parties, the judge was satisfied that wife was vulnerable due to her past experiences. I think she had been in an abusive relationship previously, and those experiences, and that she was under pressure at the time she entered into nuptial agreement. Nonetheless, the court took the view that this pressure was not undue pressure that will lead to the agreement being vitiated. So her pressure was self-created in essence. In regards to husband's behaviour, the court could not objectively describe that as coercive controlling behaviour, and nor did it lead the wife to enter into nuptial agreement. So the wife's conduct case here basically failed. The court also noted that at the time of the agreement, there appeared to be an acceptance by the husband that the agreement failed to meet her long-term income needs. And there was further discussion between the parties about further provision from wife's pension if he died before her. The judge found that the parties were unlikely to have intended that in the event of a marriage breaking down, one partner would be left with more of the assets or in real need. And that if that was the case, it would be likely to have been unfair to hold either of them to the nuptial agreement. So if you recall, wife was trying to argue for equal sharing. The court said this was unsustainable. Nearly all of the assets were owned by the husband before the relationship. Any further assets were acquired were premarital funds, and there was no evidence for the court that an increase in husband's assets, that there was an increase in assets during the marriage, except for his pension. There was a pension growth, but that could be dealt with by way of a pension sharing order. So I think given that the agreement didn't meet the wife's needs adequately, the court made the point that the energy and costs spent on looking at conduct was unnecessary. And that did play out when it came to cost consequences, unfortunately. So I think it further highlights the point about clients and solicitors thinking carefully about which points they wish to litigate on when challenging nuptial agreements before the court. So wife's needs were assessed at £378,000, 545, and that came to, in terms of division, it was 293,261 for capital and a 12.1% PSO. So again, sadly, there was a costs order against the wife, and the court made a point that her approach towards the nuptial agreement by pursuing conduct was misconceived and it added nothing. The court also made a point that her sharing claim was unarguable. So I think Maria will agree with me that when it comes to nuptial agreements and challenge them before the courts, clients should think very carefully about what they're going to be arguing. I think all the cases on the spreadsheet that Maria's pointed out, where the court does adjust the nuptial, is down to fairness and mostly needs. So I would certainly say looking at needs is very important before trying to present sharing claims or even running conduct, because it can have cost consequences. Again, when it came to costs and open offers, wife set her offers too high. And whilst husband was close to what she got in the end, his somewhat half-hearted reliance on a nuptial was unrealistic. So the court did make the point that it was unrealistic, given that he accepted it wouldn't meet her long-term needs. And just making a very brief point about long-term income needs, whilst when they prepared this nuptial agreement, it met the wife's needs at the time. As time went on, her needs changed. So it just emphasized the point about reviewing these documents and making sure that they are still appropriate when you wish to rely upon them. But Maria will touch upon that more in a moment. The final case, which is obviously more recent, is SC and TC. That was heard by some Judge Hess this year. So the husband, in that case, visited a sex worker and racked with guilt, he confessed to wife. The wife determined to end the marriage, but husband persuaded her to continue in the relationship. So the wife asked the husband to enter into a post-nup in which she would recover about 80% of the assets And at the time, the assets were £5.8 million. So she basically said that if we were to separate, I would have 80% of the assets in event of divorce, and that would apply despite your health or our age. And at that particular time, husband had Parkinson's disease. So that's obviously very important, that proviso in the nuptial agreement. Both parties took legal advice from leading solicitors. Husband was advised very firmly that the nuptial would be unfair to him. Husband maintained his position, and he would agree to the agreement, to the nuptial agreement, and to sign it. And he didn't wish to negotiate the terms, even though he understood very clearly what it would mean for him in terms of his future care needs. The marriage broke down some 7 years later, and husband's lawyers expressed the view that the agreement was not determinative. Having heard this, wife applied to the courts for notice to show cause why husband should not be held to the terms of the agreement. The wife's case was that the agreement was effectively determinative. Husband argued that the agreement carried no weight and that the fair outcome was for the assets to be divided equally between the parties. So very different positions between the both of them. Husband also made the point that while strictly he would require more than half of the assets to meet his housing and future needs, he would accept half of the assets. At date of trial, the total assets were £4.85 million. So at trial, the court found that husband needed 1.85 million to rehouse, plus a further 1.6 million to meet his own income and care needs. To meet those needs, husband would need more than half of the total net asset. So a very different picture to the other cases on the spreadsheet. The court found that husband would not be held to the nuptial agreement and the assets would be divided equally. So the reasons for that decision were as follows. So the agreement had features which place it firmly into the category that the court should attach weight to. So just to remind us of the Radmacher factors and the guidelines there was proper disclosure. Both parties had top quality legal advice. They were highly intelligent parties and they knew what they were getting themselves involved with. So there was no doubt about the intentions or what they were getting involved with. However, the court noted that the agreement was very much to husband's disadvantage financially. The overall conclusion was that husband was vulnerable when he signed the agreement. So husband had Parkinson's disease. There was a concern by the court by the extent to which it impacted on his understanding. And the court stated that wife took advantage of husband's vulnerable situation to gain a substantial financial advantage. So I think that's very important, that point there. Upholding the agreement will leave husband in real need and ran the risk of him having no choice but to go into a care home if he became very unwell. Whilst husband anticipated this when signing the agreement, this was undermined by the question marks over his ability to understand at the time. So in sum, husband's needs required more than half of the assets, but the court agreed with husband's concession and that he could manage on an equal split. So I think these cases highlights the relationship between nuptial agreements and needs and fairness. And I hope they've given you insight into how clients should run their cases if they wish to challenge nuptial agreements, or if you have a client who wishes to rely upon those agreements at court.
Thank you. Before we move off that slide, can we just move back to it very briefly? Because the one thing I'd ask you to look at is all those cases that are highlighted red, the court did not uphold the prenuptial agreement. What's of interest to us is where I've tried to define what the asset base is. I say tried to define because it's been really different from judgment to judgment. The asset has not been in the same part of every judgment and it's not clear in every judgment, but checked and rechecked, and do believe this is accurate. You've got total asset base, then you've got the award. What I've then sought to do is then translate that into percentage. And what you can see is that where the courts have departed from the terms of the prenuptial agreement to make an award outside of it to make needs, Nonetheless, those needs have been assessed at quite low percentages. If you look, you've got, for instance, in DB and PB, 18%, then above that KA and MA, 12%. Only where you get up to AD and BD, you've got 50%, but what I do believe that's one which included Duxbury Award, as did WC and HC. So whilst the courts have departed from the terms of the prenuptial agreements to meet needs and therefore fairness, those needs are not being assessed at the same level they would be were there no prenuptial agreement, I would say, given that we're nowhere near sharing, absolutely nowhere near. And when you read the judgments, as we did each and every one, although it's not strictly set out, it looks as though we're assessing needs not generously, but at subsistence level. And that's worth remembering, that even if good drafting, lots of work, ultimately leads to the court departing from it, the awards being made quite stingy. So then we move on to consider, having drawn all this together, and upon the basis of all this, what should we be looking for? What are the headlines when drafting a prenuptial agreement? This almost seems trite, but it's worth remembering that each nuptial agreement then needs to identify and set out what's to happen on separation for each of these types of assets. Your prenuptial, your premarital assets, your family home, your trust assets, your joint assets, personal belongings, pensions, debts, and one where we've seen repeatedly in those cases where the courts depart from the terms of the prenuptial agreements, there was no provision for, or insufficient provision for, maintenance. So to meet long-term income needs, and that's worth putting in. Now, of course, maintenance needs when you're young and you're getting married may be very different, and parties' views of what their needs are may be very different at the end of their marriage. And that's why it's worth stressing you need to have review clauses in. Most do, however, they need to be followed through. You also need to then define what those review clauses or trigger dates, trigger events for review are. Include in your prenuptial agreement also, let's move on to the next slide, confidentiality agreements, if any, and where there are children, make provision for the children. So Schedule 1 of the Children Act type orders. Again, we're seeing when we look back and look at the courts departing from the terms of nuptial agreements because it didn't meet parties' long-term income needs, question whether those would have been provided for had we had Schedule 1 type orders providing for children. Other matters to include, this may well be trite, cost of the prenuptial agreement, attached to the agreement, a declaration that each has provided full, frank and clear financial disclosure and attached schedules. What is commonly coming out of these cases and what we've read is there hasn't been full disclosure, or each is arguing there hasn't been, and that therefore there's not adequate financial provision. And finally, there needs to be a stated intention that the nuptial agreement is legally binding, which just deals with arguments later on of duress and coercion. Although, as Stephanie said, the courts appear to be giving short shrift to those types of arguments now. So what should not be included in the prenuptial agreement or post-nuptial agreement? Well, nuptial agreement cannot prejudice the interests of any children of the family. It's common to build in a provision for review of the nuptial agreement when the parties have children, so that their needs can be considered and assessed at that time, with possible changes made to any expectations of the adults. In a divorce, we all know first consideration is always given to the children, so it's really worth making sure that that's provided for. And next, the nuptial agreement will usually include a jurisdiction clause confirming that the parties are either domiciled in England and Wales or else habitually resident here. And it's not possible to oust the jurisdiction of the family court where the parties are domiciled or habitually resident in England and Wales, which seems seems logical, but I have seen recently and been asked to advise on a nuptial agreement drafted in Germany where the terms sought to exclude the family court. Of course, you can't do that. I say, of course, what you ought to know is you can't do that in England and Wales. You've got to meet so lastly, things that we draw from our case law, these nuptial agreements have to meet, should meet both parties' capital and income needs, assessed at subsistence level, doesn't need to be generous, and make sure you review them regularly.
Okay, so looking at the pros and cons of having a nuptial agreement. So having considered the guidance in Radmacher and how the courts have applied this since that decision, I'll go through the pros and cons of a nuptial. Should you have one, shouldn't you, and what's the point essentially? So a nuptial can provide certainty in the event of a future divorce. This can be an effective way to protect your assets if you've been married before, or if you have assets, your own assets or inherited or family wealth. So that's commonly the case when you've got ultra rich parties. That was the case in WCHC, where most of husband's assets came from his further family. He wanted to protect that. However, as we've seen overwhelmingly, a nuptial is not determinative in the case of a divorce. So it can sometimes provide a false sense of security. And parties must be made aware that the court may, and I think we would say are likely to make a different order than that in their nuptial agreement, particularly if it doesn't achieve fairness. So for this reason, it's sensible to include regular reviews or reviews in events of certain events occurring during a relationship. All of that said, what is also clear is that where the courts have not upheld the nuptial agreements, the fact of the nuptial has been considered. And we think because it is clear that the awards to meet needs are met to subsistence level, rather than where there wasn't a nuptial agreement, the needs can be more generously assessed. So again, looking at the case on the spreadsheet, as Marie pointed out, in nearly all of them, the capital division was below 50%, which is what you'd get, which is what you wouldn't get in a normal financial remedies case. In these cases, the awards tend to be, like I said, below 50% and sharing is avoided. So it therefore seems to us that the facts of a nuptial is almost always a factor which the courts consider and can impact an overall award. So looking at some practical matters, what do you do where one party seeks to resolve from the terms of nuptial when the relationship ends? So if a relationship breaks down and one party doesn't want to be held to terms of nuptial agreement, the other party that wishes to rely upon it can make an application to the court for notice to show cause. And what will then happen, so there's two ways to go about it. If there has not been a Form A issued, then the party that wishes to rely upon the agreement can simply make an application in Form D11, and they can identify and exhibit the agreement. So the prenup should be attached to that. And you want to explain basically that this should be upheld. You'd obviously need to look at the procedure under Part 18 of the Family Procedure Rules, and that needs to be followed. If Form A has been issued, and there is a pending first appointment, that hearing can be used to agree directions to list the application for notice to show cause. Alternatively, parties can agree directions themselves and have the FDA vacated pending the notice to show cause application being determined. So there are those routes. In terms of cost-wise, I think it's also important to bear in mind, if you are successful, you can claim your costs. And going back to those cases, if parties do not negotiate sensibly or litigate unreasonably, those can have cost consequences, even if you are successful in going behind the prenup. The court has discretion to adopt the accelerated procedure and try the issue as a preliminary issue, and again, whether or not the prenup should be held or not. I think in all, parties should assume that courts will ordinarily give effect to a nuptial agreement. The 18 cases we've considered and placed in the spreadsheet show that no nuptial is watertight. So even if they are drafted by leading law firms with full disclosure, full advice, and a full understanding of what is being signed up to, they can, it doesn't mean that they will be upheld in all cases. So I think it's very important to think about are parties' needs being met by these agreements, and if they're not, negotiating sensibly to try and avoid costly proceedings.
So we end our talk here simply with an observation rather than a lot of advice. Nuptial agreements have regularly been used in religious ceremonies, and we're not going to deal with them in any details, but it may be something that should be considered when dealing with parties who've had a religious ceremony, and whether that's a religious ceremony and a civil ceremony or not. There may be nuptial agreements which they may want to consider and raise as a fact at the end of any relationship. So in the Jewish faith, you've got the ketubah, the agreement of Beth Din, and the agreement for mutual respect. And in the Muslim faith, you've got the nikah, or the marriage contract, and the mehr, the Islamic dowry, both which can include agreements in respect of finances at the end of a relationship. So worth considering before marriage, and then worth considering at the end of the marriage. So we end here our short webinar. We hope it's been of use to you. And as I said, we will send out copies of our slides so that you can consider and scrutinise the schedules that have been considered today. If you've got any questions, please do hopefully pop them in the, let me look, we've got one. We've seen how many prenups have been overturned when tested against fairness. If we do a prenup and the marriage then breaks down and the other party challenges the prenup, what is the current position, on prospective conflict in representing the prenup client in the divorce? Well, good question. I did notice that in one of the more recent cases, Stephanie, that you dealt with and talked about in more detail, where the wife hadn't signed the prenup, she had the same set of solicitors representing her who had represented her in the prenup. So, and that was that I raised an eyebrow on that and thought, surely there's a conflict there, but clearly not. I don't think there's a definitive answer there. I would have thought if there's a conflict, it's either going to be that it's raised by the other side, and you have to deal with it appropriately. I think each case must turn on its facts. As I said, one of the more recent reported cases which Stephanie dealt with, 2022, there was a prenup and then there was a post-nup, and that was that post-nup which the wife hadn't signed, although there was clear evidence before the court that there had been communications, correspondence that passed between both sets of solicitors, which identified that there was an agreement. Yeah. And that was the same set of solicitors which represented her in the show cause, whom had represented her and been party to this prenup. So I don't clearly think there'd been a challenge. Although it might be much easier for a spouse to say, I was put under enormous duress and I wasn't given the accurate advice, if they're not represented by the same set of solicitors. Yeah. It might be actually pretty professionally embarrassing for you if you're trying to run that case. Another question I've got a case where both parties are French but living in rented accommodation in London. The parties are due to marry next year. The wife has about 1 million in capital. I've been asked to consider a prenuptial agreement which has been drafted in France by the wife's solicitors, and the prenuptial agreement states that if the marriage is to end, the wife will keep her 1 million. What do you advise on the validity of the prenuptial agreement? Well, it's difficult to say, isn't it, when their marriage would end? But from what we've seen, if what you're saying is the wife's got 1 million and there are no other assets, and the prenuptial agreement seeks to ring fence all of her assets and give them back to her, which would effectively mean end of marriage, husband takes nothing, highly unlikely that would be upheld. And I say that on the basis of looking at the cases that we've considered between 2010, 2022, if you make no provision for the other party's needs, which must include a home, as I said, it will depend on its facts, but if you make no provision at all, highly unlikely that the court's going to uphold that.
Yeah.
That said, so it depends what she does with it. So if, for instance, we use the 1 million, we buy a marital home and the wife says it's my home, it's my 1 million, that's unlikely. You've then placed them in a standard of living where they've got their own home. The court's going to put him into a home. He's obviously going to, it depends on what mortgage capacity he's got, what other assets he's got. It will all be dependent. But if you're seeking to say, I've got 1 million, I'm going to take out 1 million, I think a walk through all of the cases would tend to indicate that's unlikely to be something that the court's going to uphold. So in that French example, what would you advise the husband? Well, it's going to be easy for the husband because that's not going to, I think at this stage, to avoid costly proceedings at the end of it, it's probably worth trying to get your prenuptial agreement right now rather than challenging it later. If you're pushed into a position that you do agree to it, you're going to be saying it's undue duress at a later date at the end of your marriage. If you agree it readily because you love your wife and your solicitor gives advice and you say, irrespective of your advice, I'm going to agree with my wife. I love her to the end of the earth and I know she'd never cheat me. The end of that marriage, he's going to seek to get out of it. And I think probably rightly so. If the only assets we've got is 1 million and the wife says, that's mine, I'm taking it. And there's no provision for housing. It's going to depend on a whole load of things. If you've got children by then, what's his working capacity? But either way, let's say we've got two parties, end of marriage, no children, exactly the same, healthy, young, income capacity, but we've got 1 million, which has either been mixed into a marital home or something. He's going to be placed into a property. I would say it's probably highly likely, but rather than generously assessed, subsistence level, and you're not going to get sharing. And I say that on the back of all of these cases we've seen where parties' needs are assessed at the end of the relationship. They're nowhere near sharing. And they're nowhere near generous. We've got 8%, 12%, 16%, something like that, up to around about the case that you talked of recently, Stephanie, where the wife got 38% and a Dux pre-award on top, but nonetheless, she was seeking sharing, she got 38%, so nowhere near sharing. So long-winded answer of, not sure that that's going to be a nuptial agreement. It might well be binding in France, but in England and Wales, that's not likely to be something which a family court judge is going to uphold.
So I think Maria is another like a follow-on question to that point. Actually, I think they've clarified that. How would you consider structuring a prenup to be fair to the husband to be? So I think that's often a matter of drafting. Husband needs to go and get solicitors, but like Maria said, it would be unfair. You'd want to ensure you have housing provision with that prenup. I think it'd be sensible to make provision for children, if you at least thinking about that in the future, if that does happen. But I think you need to go to solicitors because they'll look at your assets, your position, looking at what you will need long term, not just for now, and ensuring the agreement reflects that as much as possible. There's another question from, would you expect to see any form of separate disclaimer if the client goes against advice and would be mentioned in the prenups? Well, I think that goes back to SC and TC, where husband clearly was advised that this would be unfair, and he still went ahead. Now, I think naturally lawyers, we want you to sign something that we would have advised you and you've not taken advice. But again, I don't that doesn't stop the nuptial being drafted and signed. It can still be opened in the future, which tends to be the case anyway. I think then goes
but
to,
you think the fact of your disclaimer producing that at the end of the marriage in the proceedings then may well have had some sort of persuasive effect on a judge thinking, well, he was clearly advised it was insufficient to meet his needs. I've got the disclaimer there. The solicitors felt it wasn't appropriate. I'm not going to hold him to it. So it's the wife who should be thinking in those circumstances, we need to redraft this because otherwise, what's the point of it? It's not where the paper is written on, is it?
Yeah, I agree. Because I have one like that at the moment, actually, where it's similar, where husband actually was advised that this is just not fair, but he still went ahead because he wanted to get married. I think I'd agree if the court would be thinking actually it was unfair to begin with. So I would be more inclined to go behind it if it started off unfair. So I think Muslim just adds weight to the unfairness, actually.
Yeah, I think what you need to do is then look and think, well, how can we make it fair? You can take people's you need to make provision for people's needs, housing and income. even at subsistence level. So where you go back to your two French couples who, if they were young and they're childless, set out that in the event of our relationship breaking down, I'll make sure you're housed, and we're currently happy and rented. I'll place you in a rented property. I'll pay it for a couple of years, something like that. So subsistence level, or I'll place you in a 1-bedroom flat. As long as you make that provision, then you're more likely to have a judge uphold it later on.
Mhm.
I think we've come to the end of our questions. Wonderful. Well, I've enjoyed this. I hope you have. If you've got any other questions, please do reach out to us. These are our contact details. And thank you for joining us.
Thank you.